A very good evening to everyone who have joined us today to be a part of this academic initiative. I am Sankirtana A, a law student. I will be a moderator for the lecture series. I take immense pleasure in welcoming all the esteemed members of the KSBC Law Academy, distinguished advocates, lawyers, academic scholars, students, and everyone else who have joined us here today to be a part of this imperative lecture series. Today is the first day of the week-long lecture series. The three new criminal laws, which came into effect on July 1st, are slowly but surely changing the dynamics of our justice system. This lecture series will indeed help us get a deeper understanding of the same. We request you to remain on mute throughout the duration of the event. Now, I would like to call upon Mr. Koteshwar Rao sir, member of KSBC, to deliver the welcome address.
Good evening, everybody. It is immense pleasure to welcome our Gurugalu, Venkata Sudarshan sir. Sir, namaskara.
ನಮಸ್ಕಾರ ಸರ್. ನಮಸ್ಕಾರ. ನಮಸ್ಕಾರ.
ಸ್ವಲ್ಪ ನಿಮ್ದು ಸ್ವಲ್ಪ ಮೇಲನ್ ಸರ್, ಅದು ಫೇಸ್ ಎಲ್ಲ ಕಾಣ್ತಾ ಇಲ್ಲ.
ಓಕೆ 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 ಓಕೆ. ಇವಾಗ
ಸ್ವಲ್ಪ ಕೆಳಗೆ, ಸ್ವಲ್ಪ ಕೆಳಗೆ.
ಓಕೆ ಇವಾಗ
ಓಕೆ ಓಕೆ ಸರ್.
Sir, now it is fine, sir.
Okay, sir.
The KSBC Law Academy intending to start the legal awareness program to the advocates. As new laws has came into force now it is using by the courts. That laws each and every advocate should know. ಯಾಕಂದ್ರೆ ನಾವು ಎಷ್ಟು ಸೀನಿಯರ್ ಅಡ್ವೊಕೇಟ್ ಆಗಿದ್ರೆ ನಮಗೆ ಗೊತ್ತಾಗಲ್ಲ. ಈಗ ನಾವು ಓದಬೇಕು, ಎಲ್ಲರೂ ಇದು ಮಾಡಬೇಕು. ಸೊ ದಿ ಎಕ್ಸ್ಪರ್ಟ್ಸ್ ವಿಲ್ explain what is the difference between the old act and the new act, what the new clauses were inserted, how it will affect in the judicial proceedings. That will explain by our honorable retired district judge and retired and session judge, the Dr. Venkata Sudarshan, who is also resource person to the Judicial Academy regularly, and he will guide all the judicial officers each and every day. So a good speaker in respect of the Bharatiya Nagarika Suraksha Sanhita.
Suraksha Sanhita.
ಅಲ್ಲ, ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಜರ್ ಕೊಡಿದ್ರೆ ಈಜಿ ಆಗ್ತಾ ಇತ್ತು, CRPC ಅಂತ. ಈಗ ಹೊಸ ಅಂದ್ರೆ ನಾವು ಕಷ್ಟ ಬಿಡ್ಬೇಕಾಗ್ತದೆ.
ಸ್ವಲ್ಪ ದಿವಸ ತಗೊಳುತ್ತೆ.
Welcome all the members of the legal fraternity who are attending this legal workshop, and to learn from the legal workshop and utilize your profession. Thank you one and all. Welcome, sir. Now we can start, sir.
No, one second.
Thank you so much.
A formal introduction will be
Thank you very much, sir.
a formal introduction, sir.
Okay, sir. Okay.
Thank you so much, Koteshwar Rao sir. Now I would like to call upon Ms. Dasha ma'am to formally introduce our esteemed speaker.
Good evening all. It is my honor to introduce a distinguished individual whose career and contributions have left an indelible mark in the field of law and justice in Karnataka. Allow me to present Shri Dr. Venkata Sudarshan sir. Sir was born in the year 1955 in Dodbalapur, Bangalore. He pursued his academic aspirations with vigor, earning a BCom degree and an LLM degree in intellectual property and technology law. Sir commenced his legal career in the year 1978 as an advocate in Bangalore. His early years saw him practice under the guidance of notable advocates before he began practicing independently in Dodbalapur. In February 1987, he joined the Judicial Service of Karnataka, serving in various capacities until his retirement in the year 2015 as a principal district and sessions judge in Kalaburgi. Throughout his career, Sir has held significant positions, including Judicial Magistrate First Class, City Civil and Sessions Judge, and Deputy Secretary of the Karnataka State Legal Services Authority, among others. His judicial postings took him across the state from Bangalore to Mysore and from Bangalore to Kalaburgi, where he dealt with a wide range of cases, including civil, criminal, and has presided over special courts to try offences under the PTCL Act. Post-retirement, his dedication to public service continued as he was appointed by the government of Karnataka as the president of the Consumer Dispute Resolution Forum, serving in Shimoga and Bangalore. His commitment to education and law is further exemplified by his association with the Karnataka Judicial Academy, where he has been a resource person since 2007, providing training to judicial officers. Sir has also been an influential educator, serving as an adjunct professor at MS Ramaya Law College, delivering and also delivers lectures on various law subjects in various institutions and platforms. His passion for teaching and sharing knowledge is evident through his numerous engagements with law colleges, advocate associations, and legal forums. In addition to his legal and educational endeavors, Sir has played a significant role as an arbitrator and inquiry officer. He is on the panel of the Arbitration and Conciliation Center in Bangalore and has also been appointed as an arbitrator in several cases by the High Court of Karnataka. Beyond his professional achievements, Sir has also had a deep involvement in religious and spiritual activities and hobbies that include reading, playing chess, and listening to music. Today, we are privileged to have with us a person of such exemplary dedication, wisdom, and service. Please join me in welcoming Shri D.R. Venkata Sudarshan, sir.
Thank you. Thank you very much, madam. Thank you.
Thank you, Darshana. I request all the audiences to send across your questions in the chat box only. After the lecture is over, some of the selected questions will be posed to our esteemed speaker by our panelists. Kindly utilize this opportunity. Honorable Justice Speaker, now the forum is open to you.
Just 1 second.
Yes, sure, sir.
Ellarigu namaskara. Very fine. Good evening to one and all. Am I audible?
Yes, sir.
Am I audible?
Yes, sir.
Yes, sir. Yes, sir.
Yes. Yes. Okay. Respected Senior Advocate Mr. Koteshwar Rao, Shri Gautam Chand, the learned Senior Counsel and also the President of the Law Academy, KSBC, all the learned advocates, those learned advocates and other persons who have joined this platform. It's my great pleasure that I have been associated with this workshop by the Karnataka State Bar Council Law Academy to speak on an important branch of law, that is on Bharatiya Nagarik Suraksha Sanhita, which has replaced the Criminal Procedure Code. In fact, I have been also been advised or rather instructed by Mr. Shri Gautam Chand, that my talk should more concentrate on the youngsters or the young generation or the freshers who have just now joined the profession, because it is necessary to inform them about the fundamentals of the criminal jurisprudence. I once again thank the Karnataka State Bar Council and also the President of the Law Academy of the Karnataka State Bar Council for providing me this opportunity. So far as the subject that has been slated for today's discussion by me is Bharatiya Nagarik Suraksha Sanhita 2023. I will be discussing about this subject for a period of 4 days from now on. At the same time, every day from this day to 19th of this month. The first and the foremost aspect that we have to consider is that an advocate who is practicing on a criminal side and a judicial officer who is presiding over a criminal court must be well versed with the provisions of the procedural law, in addition to the relevant penal laws. In the absence of having a thorough knowledge or a fair knowledge of the procedural law, it may not be possible for either the advocate practicing on the criminal side or for a judicial officer presiding over a criminal court to discharge their respective duties and functions even for a single day. Therefore, there is a need to know thoroughly about the provisions of the BNSS, which has replaced the Criminal Procedure Code of 1973. At the outset, I would like to concentrate upon the aspect as to why there was a need for bringing a new act in place of a court, a new Sanhita in place of a court. What is the object behind introduction of this new law? The object and reasons for bringing Bharatiya Nagarik Suraksha Sanhita can be stated as under. The object behind the introduction of new law is because the government considered it expedient and necessary to review the existing criminal laws with an aim to strengthen law and order and also focus on simplifying the legal procedure so that ease of living is ensured to a common man. So, the very object and reasons for bringing Bharatiya Nagarik Suraksha Sanhita is keeping the common man as the centric point. The another important object is that the government also considered to make existing laws relevant to the contemporary situation and provide speedy justice to the common man. According to my knowledge, this object would mean that we have been witnessing that since last 30 to 40 years back from now, India is developing in all fields, including the field of science and technology, electronics and digital era. This has paved way, or this has given room for the miscreants to commit various types of criminal acts using electronic media or digital record. The Code of Criminal Procedure, which was there in force till 30/6/2024, might not be in a position to cope up with this type of new activities that were going on. And in addition to that, even the day-to-day transactions of every common man, even a common man, including a common man, rather I put it, is concentrated more on electronic media and also the digital record. Therefore, there is a need for revamping the whole criminal justice system, that is criminal laws, in order to suit the contemporary situation, so that even such type of crimes could be detected easily, and thereby the justice delivery system could be made more easily accessible to a common man. With these two objects in mind, this Bharatiya Nagarik Suraksha Sanhita 2023 has been introduced. And this new Sanhita has come into force from 1st of July 2024. The parliamentarians, while making law, the lawmakers, have taken note of the following facts, perhaps, while enacting a new law. Number one, fast and efficient justice system was considered to be the essential component of a good governance. Number two, in spite of that, there was a delay in delivering justice, which was due to, number one, complex legal procedures. Number two, large dependency of cases in courts. Number three, low conviction rates. Number four, insufficient use of technology in investigation. Number five, delays in investigation system. Number six, inadequate use of forensics. Number seven, unwarranted adjournments. They were the biggest hurdles in the speedy delivery justice system. Therefore, there was a need for a citizen-centric criminal procedure, keeping in mind the contemporary needs and aspirations of the people in conformity with the constitutional and democratic principles that is what which was felt by the lawmakers. As a result of this, Bharatiya Nagarik Suraksha Sanhita has come into force, which has repealed the Criminal Procedure Code. And another important object perhaps appears to be that even prior to the Code of Criminal Procedure Code 1973, there was a Criminal Procedure Code of 1898, which has been repealed by the 1973 Code. And still that particular code contains the traces of the British system. And therefore, the parliamentarians must have thought that should also be removed and it should be made as more more adaptable to Bharatiya. Therefore, Bharatiya Nagarik Suraksha Sanhita has been introduced. These are the objects, according to me, as I could understand from reading of the literature, as the object and reasons for bringing a new Bharatiya Nagarik Suraksha Sanhita. Before actually going to the topic relating to Bharatiya Nagarik Suraksha Sanhita, I am of the considered view that for a young lawyer or a newcomer to the profession must always keep in mind certain fundamental aspects of the criminal jurisprudence. Unless he keeps in mind certain fundamental aspects of the criminal jurisprudence, it may not be possible to understand the real scope of the criminal law. What are the fundamental aspects of the criminal jurisprudence? It has to be noted that the Constitution of India, which is the supreme in our country, has given 8 fundamental guarantees to an accused person, to a person who is accused of an offense. Those fundamental guarantees are found in Part 3 of the Constitution. They are found in the form of Article 20 and Article 22. Article 20 of the Constitution provides four fundamental guarantees, which are, number 1, no person shall be convicted of any offense except for the violation of law in force at the time of commission of the fact charged as an offense. What do we mean by this? The meaning is, if a person commits a particular act at a particular point of time, that it is punishable under any law for the time being in force as on that particular day. ಒಬ್ಬ ವ್ಯಕ್ತಿ ಯಾವುದೇ ಒಂದು ಕೃತ್ಯವನ್ನು ಮಾಡಿದಾಗ ಆ ಕೃತ್ಯ ಮಾಡಿದ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವುದೇ ಒಂದು ಕಾನೂನಿನಲ್ಲಿ ಅದು ಶಿಕ್ಷಾರ್ಹವಾದ ಅಪರಾಧವಾಗಿದ್ದ ಪಕ್ಷದಲ್ಲಿ ಮಾತ್ರ ಅಂತಹ ಕೃತ್ಯಕ್ಕೆ ಶಿಕ್ಷೆಯನ್ನು ಕೊಡಬಹುದಾಗಿರುತ್ತದೆ. That is the first fundamental principle which has to be gathered, which can be gathered from Article 20 of the Constitution. The second one is, no person shall be subjected to a greater punishment than what is inflicted in the law in force as on the date of the commission of the offense. The meaning of this is, a person who has committed an offense on a particular day, if it falls under a particular section or a particular provision of the penal law, which provides for a particular term of imprisonment, he will be subjected to that particular provision and that particular term of imprisonment only, and not greater than that, even if subsequently that section is changed and enhanced punishment is prescribed on subsequent dates. So what was the punishment that was prescribed for a particular act which amounts to an offense as on the date on which it was committed will have to be taken into consideration. That is the second fundamental guarantee that is given to the accused. The third one is, no person shall be prosecuted twice. No person can be prosecuted and punished more than once. Double jeopardy. So if a person has already been tried, prosecuted and convicted once, he cannot be tried again for the same offense. And the fourth fundamental guarantee that has been given to the accused under Article 20 is, no person who is accused of the commission of any offense can be compelled to be a witness against himself. That is, no question of self-incrimination. An accused cannot be compelled to be a witness in a case against him, and he cannot be compelled to be a witness. These are the 4 fundamental guarantees that are found in Article 20 of the Constitution, which is in Part 3. Then there are 4 more guarantees which are given to the accused under Article 22 of the Constitution of India. What are those 4 fundamental guarantees? Number 1, no person who is arrested shall be detained in custody without being informed of the grounds of arrest. Means, if a person is arrested by a law enforcing agency, it is the duty of the law enforcing agency to inform that person about the grounds upon which he is arrested or he is going to be arrested. This is, so accused has got a right to ask the law enforcing agency who wants to arrest him as to why and on what ground he is going to be arrested. This is another right given to the accused. The second one is, no person who is arrested shall be denied an opportunity of having a counsel of his choice. So a person who has been arrested will have a right to contact and consult an advocate of his choice. That is also a fundamental guarantee given to him. Number 3, every person who is arrested and detained shall be produced before the nearest magistrate within 24 hours from the time of arrest. Of course, excluding the time taken for journey from the place of arrest to the court. And the last fundamental guarantee that is given under Article 22 is no person shall be detained in custody beyond the said period of 24 hours without the authority of the magistrate. That means the officers who are empowered to detain a person cannot detain a person beyond the prescribed period without the authority of the magistrate. These are the 8 fundamental guarantees that are given to the accused under Constitution of India. So these are the fundamental things which a lawyer or a judicial officer who is entrusted upon the task of the criminal justice delivery system should be aware of. Then one more aspect which should be kept in mind always is with regard to the standard of proof. The standard of proof that is required in a criminal trial is higher than what is required in a civil case. In a criminal trial, the standard of proof is something higher than what is contemplated for a civil case. The burden of proof, as all of us know, is always on the prosecution. And it is the duty of the prosecution to prove the guilt of the accused beyond reasonable doubt. Beyond reasonable doubt can be explained only in few words like this for the present. That is, beyond reasonable doubt means the evidence, both oral and documentary, which is before the court, if perused, must unerringly point towards the guilt of the accused and accused alone. There cannot be any hypothesis, and the entire evidence that is placed on record must exclusively point towards the guilt of the accused, point towards the accused as the only guilty person. It is that standard of evidence or proof that is required in a criminal case. So these are the points which are to be kept in mind, fundamental aspects which are to be kept in mind by us. Now coming to the Bharatiya Nagarik Suraksha Sanhita. It may not be Bharatiya Nagarik Suraksha Sanhita has virtually replaced the Criminal Procedure Code of 1973. In Bharatiya Nagarik Suraksha Sanhita, we have 531 sections as against 484 sections which were in Criminal Procedure Code. Yes. It is always necessary for a law student, we are all law students only, it is always necessary for a law student to keep in mind that a preamble and the definition portions in any enactment, in every enactment that we read, has to be read first. Preamble has to be read for the simple reason that the preamble tells you about the scope of the act, object of the act, purpose of the act, and the methodology in which that act is going to meet that particular object. So reading of the preamble will enable us to understand the scope, nature, and purpose of the act. Once we understand the nature, scope, and purpose of the act, when we are reading the remaining sections of the code or the act, it will be easy for us to understand those sections in the backdrop of the nature, scope, and object. Therefore, reading of a preamble is very, very important. This is all only for youngsters, freshers, who are just beginners in the career. Then the definition clause is also very important in every enactment because the words, terms and expressions or phrases which are used in that particular enactment, when defined in the definition section, they carry the same meaning as has been defined in the definition section. So whatever the meaning that is attached to those words terms or expressions in the definition clause to that particular word, will have to be understood in the same manner when the similar words, terms, or phrases occur in any part of the particular enactment which we are reading. Keeping this in our mind, we have to read the important definitions that are found in the definition section of the Act or the Code. So keeping that in mind, let us just walk through some of the important definitions that are found in the BNSS and also in the CRPC. Almost all definitions which are found in CRPC have been incorporated as they are in the BNSS also. The first and the foremost definition which I would like to take for the discussion today is the definition of the word offense. Because unless we understand the definition of the word offense, it is meaningless to deal with the criminal law. When we are talking about the criminal law, we are always concerned with the offense, nature of the offense, ingredients of the offense, scope of the offense, and the punishment that is prescribed. Therefore, it is essential for a law student to understand what do we mean by offense. Section 2N of the Criminal Procedure Code, which is equivalent section is section 2Q of BNSS, defines an offense as any act or omission which has been made punishable under any law for the time being in force is an offense. So there must be an act. That act must be something which he ought not to have done, or there must be some omission. That is, he must have omitted to do an act which he was supposed to do, and such act or omission must have been made punishable under any of the penal laws in force as on the date on which such act or omission was done. It is only that which becomes an offense. That means to say, all acts and omissions are not offenses. Only such of those acts and omissions which have been made punishable under any of the penal laws, it is only that which becomes an offense and not otherwise. This is the definition of the word offense. Offense can be categorized into two, a cognizable offense and a non-cognizable offense. What do you mean by a cognizable offense? A cognizable offense is one which is shown as cognizable in the schedule appended to the Sanhita, where a police officer can arrest a person without a warrant. So there are two things. If we go through Code of Criminal Procedure or the Sanhita, Bharatiya Nagarik Suraksha Sanhita, we find at the end of after the section part is over, we find that there is a schedule. That schedule consists of two parts, part A and part B. That schedule has got 6 columns. The first column deals with the offenses under the Indian Penal Code, the relevant offense under the Indian Penal Code. The second column deals with the punishment, nature of the offense. For example, section 324 IPC, nature, voluntarily causing grievous hurt. Third column, the punishment prescribed, 3 years of imprisonment. Fourth column, is it bailable or non-bailable? Fifth column, whether it is cognizable or non-cognizable. Sixth column, offense means an offense which is, that is one part, and second part is when a person commits a cognizable offense, a police officer can arrest This is one.
Sir, we are unable to hear you. Can you please recheck your internet connection?
Am I audible?
Yes, sir. Now you are.
Okay, thank you.
Thank you, sir.
So another type of classification is on the basis of whether an offense is bailable or non-bailable. An offense is said to be bailable. Sorry, an offense where an offense is bailable. Again, we have to go to the schedule to find out whether the offense is bailable or non-bailable. So if the offense is bailable, the accused is entitled for bail as a matter of right. If we read section 436 of the Criminal Procedure Code and the equivalent provision with a different number, numerical number in BNSS, you find the words where a person who has been accused, who has been arrested of an offense which is not non-bailable, is arrested, detained, or produced or voluntarily appears before the court, and if he is ready to offer bail, the court shall grant him bail. The word used is shall. That means in a bailable offense, the accused is entitled for bail as a matter of right, provided he is ready to offer the surety bond, he is ready to give the bond. In a non-bailable offense, you go to section 437 of the CRPC, which is an equivalent provision you find in BNSS also without changing the content, wherein it is stated, where a person who has been arrested of a non-bailable offense, produced before a court other than the Sessions Court and a High Court, or is detained in custody or produced or brought before the court or voluntarily surrenders before the court and applies for bail, he may be granted bail. So, in a non-bailable offense, whether to grant bail or not to grant bail is left to the discretion of judicial discretion of the magistrate. So, that is another category on which the offenses can be divided into. The third category, according to me, is on the basis of the nature of trial that has to be applied. Summons trial or warrant trial. That also depends upon the offense, punishment prescribed for the offense. If an offense is punishable with an imprisonment up to 2 years, it is called as a summons trial case or a summons case, where summons trial procedure will have to be adopted. If an offense is punishable with death or life imprisonment or punishment or life or death or life imprisonment or imprisonment above 2 years, that is called as a warrant trial procedure and a warrant trial case. So that is another classification upon which we can make depending in the when we are defining the word offense. So offense, what is an offense? What is cognizable? What is non-cognizable? What is bailable? What is non-bailable? What do you mean by a summons trial? What do you mean by a warrant trial? Will have to be understood in the backdrop, the definition of the word offense. The second important definition which has to be kept in mind by a law student like me is the definition of the word complaint. It is important because colloquially we say, I had been to the police station and lodged a complaint. Actually, that using of the word complaint in that particular context is not correct if we read the Criminal Procedure Code properly. That is Bharatiya Nagarik Sanhita. If you go through the provisions of section 2H of Criminal Procedure Code, which is found or equivalent at section 2H, 2D of CRPC, 2D of CRPC is equal to section 2H of BNSS. 2D of CRPC is equal to 2H of BNSS, wherein it is stated complaint means any allegation made orally or in writing to a magistrate with a view of he taking action against a person known or unknown for the offence committed. So there must be an allegation against a particular person who may be known or unknown, and such allegation may be made either orally or in writing, and it should be alleged that the person has committed an offence, and such complaint will have to be given to a magistrate and not to the police. So what we are filing a complaint, a private complaint before a magistrate is a complaint. What we are giving to the police is not a complaint, it is an information given to the police. Please read section 154 of the CRPC, which equivalent provision section 173 BNSS, wherein it is stated, when an information relating to a commission of a cognizable offence is received by an officer in charge of a police station from any person, either orally or in writing. So that is only an information. When we go to the police station, give information in writing, that is an information and not a complaint. But of course, colloquially, we use it as a complaint also. ಆಡು ಭಾಷೆಯಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಅಂತ ಅದಕ್ಕೂ ಉಪಯೋಗಿಸ್ತೀವಿ. ಆದರೆ ಕಾನೂನಿನ ದೃಷ್ಟಿಯಲ್ಲಿ ನೋಡಿದ್ರೆ ಅದು ಕಂಪ್ಲೇಂಟ್ ಅನ್ನೋ ಡೆಫಿನೇಷನ್ ಅಲ್ಲಿ ಬರೋದಿಲ್ಲ. ನನ್ನ ಪ್ರಕಾರ ಅದು ಇಟ್ಸ್ ಓನ್ಲಿ ಅನ್ ಇನ್ಫರ್ಮೇಶನ್ ಗಿವನ್ ಟು ಎ ಪೊಲೀಸ್ ಆಫೀಸರ್ ರಿಲೇಟಿಂಗ್ ಟು ಎ ಕಾಗ್ನಿಸಬಲ್ ಅಫೆನ್ಸ್. So that is another important aspect which has to be kept in mind. When we are talking about the definition of the word complaint, there is one more extension to that particular definition wherein it is stated. Let us take, for example, a case where an information is given to a police officer relating to the commission of a cognizable offense. Say, for example, 324. The police officer registers a case. FIR is prepared. FIR is sent to the court. Investigation is done. Ultimately, the charge sheet is filed not for section 324, but for a non-cognizable offense. The law says that the police officer has no power to investigate a non-cognizable offense without the order of a magistrate. So the definition of the word complaint says, in such case, the final report submitted by the police will also be considered as a complaint, and the police officer who is submitting that final report will be the complainant. So this is the extended definition of the word complaint. You find it in section 2D of CRPC, which is equal to section 2H of the BNSS. Then the third important definition which has to be kept in mind is with regard to the definition of the word investigation. Investigation, that is found in section 2H CRPC, and the equivalent provision is 2L BNSS. There it is defined, investigation means collection of evidence by a police officer. There is no dispute about it. Further, it is mentioned, or by any other person other than a police officer, but authorized by a magistrate. So if we read this particular definition as it is, it would mean that if a magistrate authorizes another person other than a police officer to investigate into a matter, and whatever the material that he collects during that investigation will also be construed as an investigation within the definition of the word investigation as found in section 2H of CRPC, which is equivalent to section 2R. Section 2L of the BNSS. Then, one more definition that has to be kept in mind is the definition of the word victim. Section 2WA CRPC. Section 2WA CRPC, which is of which the equivalent is section 2Y of BNSS, defines victim. Victim means a person who has suffered any loss or injury caused by reason of the act or omission of the accused person and includes the guardian or legal heir of such victim. So a victim is a person who has suffered loss or injury caused by the reason of an act or omission by the accused. Let us say, for example, a person driving a vehicle on a public road dashes against the compound wall of my house. The compound wall of my house is damaged. It is demolished on account of the accident. So I have suffered monetary loss. I become the victim of the offense. The offense that he has committed may be an offense under section 279. The act has taken place because of the rash and negligent act of the driver, for which he is criminally liable to be prosecuted. But what is it that I am going to get as a victim? I don't get anything if he is prosecuted. But under law now, the victim definition has been added newly. Even under CRPC also, we had this definition. And even in BNSS also, we have this definition. So that is why there is victim compensation fund. A scheme has been framed for providing compensation to the victim of the offenses and all that. About that, we will come to know when we go through the provisions of the BNSS and or CRPC. So supposing a person suffers an injury, maybe on account of a hurt, maybe on account of a grievous hurt, maybe on account of an attempt to commit murder, or maybe on account of any other reason, or maybe on account of an accident, and he becomes a victim. It doesn't stop. The definition does not stop there. The definition further goes to say, or his legal heir, or his guardian. Why that guardian has been used? Because supposing a person who is a victim of the offense is a minor. A minor cannot go to the court and claim compensation. So for that purpose, the guardian will be the victim. Guardian of the minor will be the victim. Supposing the victim of the offenses dies, then the LRs of the deceased victim will be considered as the victim within the definition of section 2 WA CRPC, of which the equivalent is section 2Y. Then there is one omnibus clause which you find in the definition clause. That is section 3(4) CRPC, of which the equivalent is section 3 subsection 2 clause A and B, wherein it is stated, wherein it is stated that the words and phrases or the terms which have not been defined in the BNSS will have the same meaning as they have been defined either in the Information Technology Act or in the Bharatiya Nagarik Sanhita. So whatever when you do not find, for example, let us take the example of a word public servant. You find the word public servant in number of places in CRPC, section 197, for example. You have a number of places, but the definition you don't find the definition of the word public servant in CRPC. But you find the definition of the public servant in IPC. Similarly, there is no definition of the word public servant in BNSS, but you find the definition of the word public servant in BNS. So whatever the definition that is given in those acts will have to be taken as the definition to the same word used in CRPC also. So these are some of the aspects which are to be kept in mind. So far I have discussed only about the definitions which were there in the BNSS, which were there in CRPC and which are now in BNSS also. Now we will come to the definitions which have been newly added in BNSS. What are the definitions which have been newly added in BNSS? The newly added definitions are section 2, subsection 1, clause A. It defines audio, video, electronic means. What do you mean by audio, video, electronic means? It defines audio, video, electronic means. It shall include. They don't say only this. It shall include. So even in the coming days, some more things may also be included by the government. It shall include use of any communication device. Please understand. Use of any communication device for the purpose of video conferencing, recording of the process of identification, search and seizure of or evidence, transmission of electronic communication, and for such other purpose, which the state government may prescribe by rules. So, video conferencing cannot be done by a magic. A video conferencing has to be done electronically and both the ends are to be connected. And that is possible only when there is a communication device. What is a communication device? Some of the examples of communication device according to me are edge router, number 1, modem, number 2, network switch, number 3, and access points. That is, it could be a computer, it could be a laptop, it could be an Android mobile, or it could be a tablet. So they are all considered as communication devices. So with the help of these communication devices, when video conferencing has been done, or when a recording of the process of identification of an accused, identification of a property, identification of a place, whatever it is done, and search and seizure and evidence, search and seizure or evidence is done through electronic media, or if electronic communication is transmitted from one place to another, all these things are covered under the definition audio, video, electronic means. You find in BNSS at number of places you find this word, audio, video, electronic means. So wherever you find this particular phrase, audio, video, electronic means, that should be understood in the context of the definition that is found in section 2, subsection 1 and subclause A of BNSS. The second definition is section 2, subsection 1 and Roman 1, electronic communication. What do you mean by an electronic communication? Electronic communication has been defined as, it means the communication of any written, verbal, pictorial information or video content transmitted or transferred, whether from one person to another, or from one device to another, or from a person to a device, or from a device to a person. By means of electronic device, I have already explained what is electronic device, or from a device to a person, including telephone, mobile phone, or wireless. All these things are coming under the definition of electronic communication. So this is the second new definition that is found in BNSS. Which has not been defined in the CRPC. Then there is another remarkable, significant definition is bond and a bail bond. When an accused is released on self-bond, it is a simple bond. When an accused is released on executing a self-bond and also a bond with a surety, it becomes a bail bond. That is another definition which has to be kept in mind. Then coming to the hierarchy of courts. In CRPC, if you read section 3, there are the courts, district level courts, session court at the top, below that is the assistant session judge, below that is the chief judicial magistrate, below that is the judicial magistrate first class, and below that is the judicial magistrate second class. So session judge, assistant session judge, CJM, JMFC, and JMSC. This is the hierarchy of courts under section 3 of the CRPC. Now under section 3 of BNSS, what change has been made is assistant session judge has been taken away. So that is abolished. So now we have only session judge, CJM, JMFC, and JMSC. This is one important definition that has to be kept in mind. Another important change that has taken place is in BNSS, you find that there is a provision for establishment of Chief Metropolitan Magistrate, Additional Chief Metropolitan Magistrate, and Metropolitan Magistrates in a metropolitan area. What is metropolitan area has also been defined. In CRPC, I am talking about. But in BNSS, that has been taken away. No metropolitan magistrates, no chief metropolitan magistrates hereafter from 1/7/2024. So the hierarchy of courts as of now in BNSS is Session Judge, Chief Judicial Magistrate first class, and Judicial Magistrate second class. That's all the existing one. So far as Assistant Session Judges is concerned, we never had Assistant Session Judge post in Karnataka, either before or now or in future also. So this is another important aspect which has to be kept in mind. Then another important aspect which has to be kept in mind, though there is no change, here I would like to mention for the benefit of our young friends, freshers, Section 4 of the CRPC and Section 4 of BNSS. What does it say? This section is very important because it has an interconnection with IPC. How? According to me, if we go through subsection 1 of Section 4, you find the following words, either in CRPC or in BNSS. There is no change in content. What it is? All investigation, inquiry, and trial in respect of the offences under Indian Penal Code shall be conducted according to the provisions of the BNSS only. According to the provisions of the Criminal Procedure Code only. So when we are talking about the investigation of an offence under Indian Penal Code, we need not have to refer to any other book so far as the procedural aspect is concerned. We have to refer to only CRPC, that is BNSS, no other book. Therefore, a thorough knowledge of the Criminal Procedure Code, that is BNSS, is absolutely essential for an advocate who is practicing on criminal side. A small procedural mistake may cost very heavily. Therefore, we should be very careful when we are conducting criminal, when we are practicing on criminal side. Procedural aspect, we should be very careful because if a mistake is committed, that cannot be corrected at all. Unlike 151 CPC, we don't have a similar section here giving inherent powers to the magistrate courts and sessions courts. It is only to the Hon'ble High Court and Hon'ble Supreme Court the inherent powers have been given. So therefore, procedural aspect, so far as the procedural aspect is concerned, we should be very careful. This is one aspect. So far as a question may be asked, okay, what about the other laws? Indian Penal Code, it is all right, we can follow CRPC. What about the other laws? There are so many hundreds of other laws which are penal laws which are in force. What about that? For that, subsection 2 of Section 4 says, all investigation, inquiry, and trial in respect of offences under other laws shall also be done according to the Code of Criminal Procedure. However, if there is a procedure prescribed in a special law, which is different from the procedure prescribed in the CRPC, then the procedure prescribed in the special law will have to be considered and not the procedure prescribed in the CRPC, because BNSS is a general law and a special law is a special law. So a special law provides a special procedure means the lawmakers have specifically intended that that procedure all alone should be followed and not the general procedure mentioned in the CRPC. So in that context, Section 4 of the Act is very, very important. Section 15 of the BNSS provides for appointing a police officer not below the rank of a superintendent of police as a special executive magistrate. And that special magistrate, executive magistrate, can be appointed for a particular area or for performance of a particular function and confer upon him such power as are conferable upon the special executive magistrate conferable under the Sanhita. So whatever the powers that could be conferred on the special executive magistrate under the Sanhita, the same powers can be conferred on a police officer who is above the rank of a superintendent, who is a superintendent of police or above the superintendent of police, who has been appointed as a special executive magistrate. That is another important aspect which has to be kept in mind. Then, we have seen in the recent past also that number of magistrate courts did not have APPs at all. One APP was having charge of 2 or 3 magistrate courts. Perhaps in order to obviate such a situation, according to me, there is one addition made in the form of subsection 3 to section 25 of BNSS, wherein it is stated, without prejudice to the provisions contained in subsection 1, subsection 1, not 25, it is section 19, without prejudice of BNSS, without prejudice to the provisions contained in subsection 1 and subsection 2 of section 19 of Sanhita, where the assistant public prosecutor is not, for the purpose of any particular case, a district magistrate may appoint any person as an assistant case notice to the government. So this is another important change that has been brought in by way of section 19 to BNSS. Then, with regard to the jurisdiction of the criminal courts, as per CRPC, a chief judicial magistrate, so far as session judge is concerned, it remained unaltered because he can impose any sentence, including the death sentence. Of course, the death sentence can be executed only after getting confirmation by the Hon'ble High Court. That remained unchanged. So far as assistant session judges, that post has been abolished. So far as a chief judicial magistrate is concerned, he is empowered to inflict any term of imprisonment up to maximum of 7 years without upper cap limit so far as the fine is concerned. So far as the judicial magistrate first class is concerned, under CRPC, he had power of sentencing a person to any term of imprisonment which shall not exceed 3 years. And fine shall not exceed 10,000 rupees. So far as judicial magistrate second class is concerned, he can inflict a sentence of imprisonment up to 1 year and fine shall not exceed 5,000 rupees. But in BNSS, the sentence of imprisonment portion has been retained as it is without any change. 3 years in case of JMFC and 1 year in case of second class magistrate. But so far as the fine component is concerned, in section 23, subsection 2, subclass 3, there is a change. The change is a judicial magistrate first class who could hitherto, that is up to 36/2024, impose fine up to 10,000. Now that 10,000 is enhanced to 50,000 rupees. And a judicial magistrate first class who could impose fine up to 5,000 rupees, that has been enhanced to 10,000 rupees. That is another important change that has been brought out in BNSS. Then, under IPC, there are prescribed. Number 1, death sentence. Number 2, life imprisonment. Number 3, rigorous or simple imprisonment. Number 4, forfeiture of property. Number 5, fine. Now, there is one more form of punishment which has been prescribed, that is community service. Why I am discussing about community service in CRP, in BNSS, when that amendment has been done in IPC? The reason is The word community service has not been defined in BNSS. Sorry, BNS. Bharatiya Nyaya Samhitayalli BNS ಅನ್ನೋದಕ್ಕೆ definition, sorry, community service ಅನ್ನೋದಕ್ಕೆ definition ಕೊಟ್ಟಿಲ್ಲ. ಆದರೆ BNS ಅನ್ನೋದು ಸಹ ಒಂದು ಫಾರ್ಮ್ ಆಫ್ ಪನಿಷ್ಮೆಂಟ್ ಅಂತ ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಸೇರಿಸಿದ್ದಾರೆ. ಆದ್ರೆ ಆ ಕಮ್ಯುನಿಟಿ ಸರ್ವಿಸ್ ಅನ್ನೋದಕ್ಕೆ ಡೆಫಿನೇಷನ್ CRPC ಇದೆ. Therefore, I am drawing your attention to that community service component. That definition of the word community service you find in the form of an explanation to section 23 of BNSS, wherein it is mentioned, community service means the work which the court may order a convict to perform as a matter of punishment that benefits the community, for which he shall not be entitled for any remuneration. Let us analyze this explanation for a while. The work which the court may order a convict. Let us stop there. What do you mean by a convict? A convict is a person who has been already tried and found guilty. An accused has been tried and the magistrate has come to the conclusion that he has committed an offense and he has been convicted. Now he has to be sentenced. When the question of sentencing comes, then the magistrate will have to consider whether he has to be sentenced to any term of imprisonment or imposition of a community service would be adequate punishment. So it is a punishment. Community service is also a punishment. The word punishment is used in this explanation. It is also a punishment. So what is that community service? Community service means the service which should benefit the community. Community as a whole, not a particular community. Community as a whole. And for the services that he renders, that the convict renders, he is not entitled for any remuneration. So these are the essential ingredients, according to me, of the definition of the word community service as explained in section 23 of the BNSS. Some of the examples which can be, raw examples which can be given are, supposing a person who has been convicted may be asked by the court that you go and clean the public park. Morning between 6:30 to 8:30, you please go and pick all the litters or whatever the dust is there, paper ettodu, adettodu, enen kasa kaddi bidyo adalla tegadaku, clean madu. Or go to a public playground, clean it. Or go to a government hospital, render service. Or go to a recognized charitable organizations, render service, which should benefit the community as a whole. Or some social oriented programs, allowing him to participate for a particular period. These are some of the examples of community services which can be given. Of course, these are raw examples I am giving, not supported by any mention in the BNSS or in CRPC. Some of the examples which stuck to my mind, I am just placing it before you, that's all. In BNS, importantly, 3 sections have been newly added. They are section 111, 112, and 113. 111 BNS, I am talking about IPC, BNS, Bharatiya Nagarik Sanhita. Section 111 deals with organized crime. Section 112 deals with petty organized crime. Section 113 deals with terrorist act. Why I am mentioning about this? I am mentioning about this because of the provisions of section 33 of the BNSS. Section 33 of the Bharatiya Nagarik Suraksha Sanhita says that it is the duty of the public to give information about the commission of certain offences which has come to their notice to the police. In that particular section, in addition to the offences under various sections mentioned in CRPC, this 111, 112 and 113 of BNS are also included. So that is another important aspect which has to be kept in mind. With regard to other 10 sections which have been which are found in CRPC, they have been reproduced in BNSS without any change. Then chapter 5, arrest of persons. This is from section 35 to section 32 of the BNSS. In this section, from section 35 to section 36, you don't find any change. But in section 35, subsection 7, a new provision has been added to section 35 by way of subsection 7. What is it? It reads as under, no arrest shall be made. I am emphasizing, no arrest shall be made without the prior permission of an officer not below the rank of DYSP in case of an offence which is punishable for imprisonment of less than 3 years, and if such person is infirm or is above the age of 60 years. What does it mean? Supposing a person who is infirm, that is physically or disabled, or a person is aged 60 years and above, has committed an offence which is punishable with less than 3 years of imprisonment, such person, even though it is a cognizable offence, cannot be arrested without the permission of the DYSP. This is a new addition that has been made in CRPC. Then, in section 41 CRPC, which is equivalent to section 31 of the BNSS, section 41 CRPC speaks of establishment of a police control room at the state level and establishment of a police control room at the district level. There is no change, that has been retained as it is, and it is in subsection 1. So there shall be a police control room in the state at the state level, and there shall be a police control room at the district level. Subsection 2 and subsection 3 of section 41 of the CRPC have been deleted. And in its place, a new addition has been made by way of clause B, which reads as under, designate a police officer in every district and in every police station, not below the rank of an assistant sub-inspector of police. So, there shall be a designated police officer of the cadre of ASI, of the cadre of at least ASI, in every police station and in every district. What is his duty? His duty is, he is responsible for maintaining the information about the names and addresses of the persons arrested, nature of the offence with which he has been charged, and that shall be permanently displayed in any manner, including in the digital mode, in every police station and the district headquarters. When you read BNSS at the relevant chapters in relevant sections, you find the word designated police officer. So wherever you find the word designated police officer in the course of when you are reading BNSS under any section, that should be understood in the context of what has been mentioned in by way of clause B to section 37, section 37. So there is a control room at the state level and district level. In addition to that, there will be a designated police officer in every district and also in every police station whose responsibility is to maintain a register containing the names and addresses of the person who have been arrested and also the nature of the offense for which they have been arrested, and that shall be displayed in any mode, including the digital mode. This is an addition or an addition made in the BNSS, which does not find a place in CRPC. Then, another important change that has been brought about, a modification rather, I put it. A private person could arrest a person committing an offense. There is no bar for a private person to arrest. For that, you go to section 41, subsection 40, subsection 1 of BNSS. Arrest by a private person and procedure on such arrest. Any private person may arrest or cause to be arrested any person who in his presence commits a non-bailable and a cognizable offense. For example, you find a person committing an offense which is a non-bailable and a cognizable offense. Let us say, for example, when we are walking on the road, we find a person attempting to commit theft of a motorcycle which is parked on the side of the road. It is a non-bailable offense and also a cognizable offense. So as a dutiful citizen, your duty or my duty is to catch hold of that person with the assistance of other persons and hand him over to the police and subject him to the process of law. That's what this section says. Commit non-bailable or any proclaimed offender, and without unnecessary delay, that person shall be arrested. What should be done? The arrested person should be taken to the police station, and he should be made to surrender before the police, and they will subject him to the process of law. But the CRPC did not provide as to within what time the arrested person should be handed over to the police. That ambiguity has been cleared in BNSS by saying that such person who has been arrested by a private person will have to be handed over to the police immediately and not later than 6 hours. That time limit has been prescribed. And when a person has been arrested by a private person and handed over to the police, police cannot re-arrest him and they can only take him to custody. That is another modification that has been made, which you find in subsection 1 of section 40 of the BNSS. Because the time limit was absent in the equivalent section 43 subsection 1 of CRPC. Section 46 of the Criminal Procedure Code did not provide the manner of making arrest or provide for any guidelines in regard to handcuffing of the arrested person. Of course, as all of us know, that there are judgments of the higher courts which says that a person who has been arrested should not be handcuffed in all cases ordinarily. Now, the law has been introduced in this BNS in the form of subsection 3 to section 43 of the BNSS, which provides for handcuffing. What that particular subsection 3 of section 43 says? Let us see. This is an addition. The police officer may, keeping in view the nature and gravity of the offense, very important, keeping in view the nature and gravity of the offense, use handcuff while making arrest of a person or while producing such person before the court who is a habitual offender, number 1. Number 2, or who is a repeat offender. Number 3, who has escaped from lawful custody. It could be from a police custody, it could be from any other custody where he is detained. Or who has committed an offense of organized crime, terrorist act, drug-related crime, or illegal possession of arms and ammunitions, murder, rape, and attack, acid attack, counterfeiting of coins and currency notes, human trafficking, sexual offences against children, or offences against the state. Under these circumstances, the accused who has committed the offence can be handcuffed and he can be produced before the court in the same condition. This is another important change that has been made in BNSS and it is incorporated in subsection 3 of section 43. Now you see, section 48 subsection 1 says, it corresponds to subsection 1 of section 50A CRPC, where it says that the police officer arresting the person to give information regarding such arrest and place from where such person is being held to the designated police officer. I have already told you that there shall be a designated police officer of a rank not below the rank of an ASI in every district and every police station. His responsibility is to maintain the register containing the names and addresses of the persons who have been arrested and the nature of the offences for which they have been arrested, and that shall be displayed. So it is the duty of the police officer arresting a person to inform the designated police officer about the arrest, the name and address, the place from where he has been held, and the offence for which he has been arrested. So I think I can stop at this, Mr. Gautam, sir. Hello?
Yes, sir. Yes, sir.
Can I stop at this?
Yeah, yes, sir. It is very clear now. We have done more than 1 hour 10 minutes, 1 hour 15 minutes, sir. So we can go to question and answer session.
Okay, sir.
Yes, sir.
And let questions will be confined only to what I have covered.
Yes, sir. Yes, sir.
Not to the chapter which I have not discussed. ಅದು ಕೇಳ್ತಾ ಹೋದ್ರೆ ಅದು ಕೊನೆನೇ ಇರೋದಿಲ್ಲ ಅವಾಗ.
ಕೊನೆನೇ
ಏನು ಡಿಸ್ಕಸ್ ಮಾಡಿದೀವಿ ಅದ್ರ ಬಗ್ಗೆ ಏನಾದ್ರು ಪ್ರಶ್ನೆಗಳಿದ್ರೆ ಅದಕ್ಕೆ ಹೇಳ್ತಿರೋದು. ಏನ್ ಡಿಸ್ಕಸ್ ಮಾಡಿದೀವಿ ಅದ್ರ ಬಗ್ಗೆ ಪ್ರಶ್ನೆಗಳಿದ್ರೆ ಕೇಳಿ ಸರ್, ನನಗೆ ಗೊತ್ತಿದ್ರೆ ಹೇಳ್ತೀನಿ.
Yes, sir. Mr. Mallikarjun?
Yes, sir. Thank you, Honorable Justice Venkata Sudarshan, sir, for discussing the nuances of the newly implemented law. Now the forum is open for the question-answer session. Kindly requesting all the participants to send across your questions in the chat box. I request Mr. Mallikarjun, sir, to pose the questions.
Just 1 second. Mr. Mallikarjun has also done extensive research on CRPC.
Yes, sir.
And has given training to many police officers and has taken classes. So it becomes relevant and easy to choose the questions and what is relevant and irrelevant.
Very happy, sir. Very happy.
Yes.
Sir, we have one question from Mr. Chanakya. That coming to section 1. So for
is
what
it the same? One minute. Is it the same Mallikarjun who was in KLE?
Yes, sir. Rightly pointed out.
Welcome. Very happy, sir.
Thank you, sir. Same here, sir. Same here to know, sir. Sir, usually every section 1, the short title would say that this act is applicable to whole of India. Yes. Whereas the present enactment, it does not speak about that this act applies to India. So how do we infer that? They say that it is not applicable to these many states.
According to me, what has been excluded is mentioned in section 1.
Exactly, sir.
So when the section clearly says the area or the places which have been excluded, that would mean that the rest of the India is covered by this code, Sanhita.
All right, sir. So even though there is no specification that it applies to whole of India,
because the provisions of this Sanhita, other than those relating to chapter 9, 11 and 12 thereof, shall not apply to the state of Nagaland, to the area, to the tribal areas. That is mentioned. So that means for state of Nagaland and to the tribal areas. Chapter 9, Chapter 11 and Chapter 12 are only applicable and others are not applicable. That would necessarily infer that the entire provision of the Sanhita is applicable to the whole of India, according to my reading.
Yes, sir. Sir, and I have one more question. This is in respect of the arrest. Without informing a designated officer, if there is any arrest, does the arrest become illegal?
That's a question which has to be decided only in the days to come.
In the days to come. All right,
in
sir.
the days to come. We cannot form any opinion right now,
Sir.
because that we will have to see how the courts of law will interpret that particular provision and what will be the effect of such arrest when made without informing the designated police. Information should be given after arrest, not before arrest.
Sir.
After arrest. If so, no such information is given, what is the consequence? That has not been explained in CRPC. Therefore, we have to wait for the things to happen in the days to come.
Yes, sir. Now, sir, the very basic thing when you're discussing about the third aspect, the criminal, in respect of criminal cases, it is the burden of proof is very high when compared to that of civil cases. One Mr. Sharanai has posed a question. Sir, where was the concept of beyond reasonable doubt evolved? Do we find this in the Evidence Act or in CRPC?
It is the judge-made law, according to me.
It's a judge-made law.
Yes.
Yes, sir. So, sir, other sections are
the constitutional courts have laid down that principle.
Yes, sir.
That the prosecution will have to prove the guilt of the accused beyond reasonable doubt.
Yes, sir.
According to me, the reason being, as compared to civil law, in a criminal law, when a person is found guilty without sufficient evidence, that is without a highest standard of proof, liberty of an individual is involved there. Life and liberty of an individual is involved there. Therefore, the life and liberty of individual cannot be taken away lightly. Therefore, the law insists that the evidence should be such that it should conclusively establish the guilt of the accused. Unerringly, that is the word used. Unerringly point towards the guilt of the accused. Unerringly, error, unerringly.
And sir, we have other few questions that is, of course, may not be covered for today's topic, sir. They say in respect of the power of a police in respect of filing of an FIR under 173, which you have not
taken. That we will see later, sir.
Yes, sir.
You reserve those questions. You please reserve those questions. We will consider later.
Sir.
Yes, sir.
Definitely, sir. So these are the questions for the day, sir. Now I request.
Thank you very much.
Thank you, Tuna, to take up, sir. Thank you, sir.
Thank you. Thank you very much. I am seeing you after a very long time, Mr. Mallikarjun, sir.
Yes, sir. Thank you, sir.
Thank you.
We thank our esteemed speaker, Honorable Justice Retired Venkata Sudarshan, sir, for spending his precious time enlightening us about the new criminal procedural law. We are very grateful to have you as our esteemed speaker for the lecture series, sir. Thank you so much.
Thank you. Thank you very much.
Yeah, please let us know today and tomorrow's session also, Sankirtana.
Yes, sir. Yes, sir. Coming to that. This academic initiative is a week-long continuous lecture series. Beginning today, it will continue until Friday, that is the 19th of July 2024. Requesting all the participants to join us for the next 3 days as well to expand our knowledge about this vast topic. We certainly hope that this lecture series will help you better understand the nascent laws. We hope to see you again tomorrow. Thank you for attending today's session.
Thank you. Thank you very much. All the best.
Thank you. Thank you very much, sir.
Thank you, sir. Thank you.